I'm going to present on the topic of ethics of counsel. Perhaps the topic is a little bit less sexy at this very moment than the ethics of arbitrator, given the consideration of the Untitled Working Group 3 on Code of Conduct for Arbitrator this week. But I hope I'll manage to convince you it is equally important. Let me start with a quote from Jan Paulsen, which dates back to the 1990s. Arbitrators are named to resolve the dispute between the parties, Professor Paulsen noted, not to police the conduct of their counsel. Much has changed since then, when the International Bar and the Invisible College of International Lawyers serve as the primary form of regulation of international counsel. One could point to the IBA guidelines on party representation, the Hague Principles on Ethical Standard, the LCIA General Guideline for the party's legal representative, and many other initiatives. Yet, the uneasiness with the enforcement of counsel's ethical obligation by tribunal remains very much alive today. We can break it down into two commonly held views. The first is that while ethical regulation of counsel is not perfect, it works. Sure, practitioners say, it may be that members of different bar in international arbitration are subject to different ethical obligations. But this is mostly a problem in theory. In practice, there are no major issues. These obligations do not affect the arbitral proceedings, except for a few notable obligations. And national bars do not have the time or interest to monitor the conduct of counsel in exotic proceedings abroad. The second commonly held view about the regulation of arbitration counsel is that arbitral tribunal shouldn't deal with ethical issues. A few practitioners have told me, I've encountered only one or two cases of grave counsel misconduct over my long and illustrious career. And by the way, this misconduct is always on the other side. In other words, there's no need. The market regulates itself. More rule would lead to more skirmishes, be a waste of time and money. And even if more obligations were needed, it's not even clear whether and to what extent tribunal could enforce ethical obligation in international arbitration, since that's the job, perhaps exclusively, of national bars and courts. Well, given the way I've presented these two views, you might think that this was all for a rhetorical purpose, and that I'm about to say why they are all wrong. And they are wrong, but they're also right. Let me explain. No, not all is well with the ethical, with multiple conflicting obligations of counsel in practice when they exist. But yes, enacting further codes of conduct would be useless, or worse, detrimental. What's the solution then? I suggest that tribunal have the power and even the duty to enforce a certain narrow type of ethical issues. They are procedural ethical issues. This authority stems from the ground to challenge arbitral awards, but because these grounds are broadly worded, to say the least, arbitral institutions should state expressly the power of tribunal to enforce this procedural obligation and circumscribe their discretion while exercising this power. So my presentation today has three parts. In part one, I'll introduce the problem with the dual regulation of counsel and why the current solution proposed to remedy those are insufficient. In part two, I'll explain why international tribunals should enforce procedural ethical issues in the proceedings. And in part three, I'll explain why national bars and courts should enforce deontological and liability obligations related to arbitration proceedings. I come to my first part, and it begins with an elementary question. What do we mean by ethical obligations? In practice, this question matters because it explains why the problem with the current ethical regulation of counsel arises and how these problems can be resolved. First, the problems. Under most professional rules of national bars and courts, ethical obligations apply always and everywhere, including when a counsel practices abroad or in an international arbitration. There are two things certain in life: bar discipline and bar fees. They're unavoidable. Yet these national ethical rules differ significantly on issues such as witness preparation, privileges and confidentiality, and document disclosure. In international arbitration proceedings, when counsel appearing before a tribunal are licensed in different jurisdictions, they are, as a group, subject to different and sometimes conflicting obligations. But that's not all. Individual counsel may also be subject, concurrently, to the differing and sometimes conflicting obligations of the jurisdiction or jurisdictions where they are licensed, the foreign jurisdiction or foreign jurisdictions where they practice or appear, and the jurisdiction of the arbitral seat. No S this time, hopefully. This situation creates two problems in international arbitration. The first is the double deontology problem, which arises when counsel is subject to conflicting ethical rules of different jurisdictions. The second is the inequality of arms problem, which arises when the fairness and integrity of arbitral proceedings risk being compromised by one side having a procedural advantage over the other because of differing obligations. Well, these two problems go to the heart of the rule of law component that we've been discussing as part of this committee. Due process, legal certainty, consistency and predictability, legality, transparency, equality before the law. What solutions have been offered to remedy these two problems? I won't hold you in suspense. Most professional rules regulating counsel say we apply, and the other rules apply too when they're relevant. At the national level, that is what the American Bar Association, this is what the codes of the American Bar Association and the code of the Council of Bar and Law Societies of Europe say. But at the international level, that's basically what the IBA guidelines, the Hague Principle, and the LCIA guidelines say too. But these rules do not specify when they apply and when the other ones do. This is because professional rules typically assume that ethical obligations are monolithic, that they are one block, that covers all conduct and cannot be split into different components. That is incorrect. There are three types of ethical obligations. First, procedural obligations, when courts and administrative institutions issue sanctions to ensure the proper functioning of their own processes. Second, the ontological obligation, when national bodies review the disciplinary proceedings to maintain the high standards of the legal profession. And third, liability obligation, when clients and the public can bring civil or criminal proceedings against counsel to obtain redress following ethical misconduct or to deter further ethical misconduct. As I've introduced, my view is that in international arbitration, only procedural ethical obligations should be enforced by the tribunal, and that the deontological obligation and liability obligation should fall on the national bars and courts. So I'll come back to these 2 points in my next 2 parts. But before that, just one quick point. How do we draw the line between these different types of obligation? Well, the key in my view is to distinguish between the obligation owed to the tribunal on the one hand, and to the client, the public, and the profession on the other hand. So I come to the second part of my presentation. Why do tribunals have the power to enforce procedural ethical obligation and not the ontological obligation and liability obligation? Where does this power come from? How should it be exercised? My argument is that the New York and Exit Convention lay the foundation of the procedural ethical regulation of counsel in international arbitration. I submit that they do so in three indirect but very significant ways. First, the ground to challenge arbitral award mandate the procedural fairness of the arbitration proceedings. For instance, the requirement in Article 5.1b of the New York Convention that a party be able to present his or her own case, and in Article 52.1d of the Exit Convention that there be no serious departure from a fundamental rule of procedure, can be raised to regulate counsel. To take a recent example illustrating this point, you might have seen over the past couple of months the many reports in GAR about a counsel who challenged a Peruvian refinery award on the ground that some of its counsel team switched sides during the proceedings. This shows my point here. A national court or an annulment committee may refuse to uphold an award if it finds that the action of counsel prevented his or her opponent from being heard. Second, the New York and Exit Convention recognize that the parties can consent to the resolution of procedural ethical issues related to the dispute. The parties can agree at the stage of choosing the arbitration rule or agreeing to the content of the TOR, the terms of reference, and the PO1, the procedural order number 1. Third, the New York and Exit Convention circumscribe party autonomy through their notion of arbitrability and investment dispute. Ethical issues can be decided in arbitration, that can be decided in arbitration must relate to the proceedings and to the dispute, which is not the case of truly deontological obligation and liability obligation. In any case, the conventions do not intend to derogate from mandatory rule regulating the legal profession at the national level, which still apply. I'll go very quickly over a few examples showing how the requirement to uphold the fairness and integrity of the proceedings in the conventions mean that tribunals are empowered to enforce procedural ethical obligation. Well, when we look at the arbitration rules and the soft law instruments, we see through their evolution over the past couple of years that they focus more explicitly on the fairness and integrity of the proceedings and have become much more detailed on ethical or ethics provision as well. Also, tribunals have increasingly used the tools available to them to regulate the procedural ethical obligation of counsel, notably through their inherent powers. For example, in the document production stage, a tribunal can seek the views of each party about the searches and objections mentioned in a Redfern schedule and can use its discretion while ordering production in order to level the playing field between counsel subject to different obligation at the national level, for instance, counsel from civil law or common law countries. I come to the third part of my presentation. I'll explain why national law should regulate and regulate only deontology and liability obligation related to counsel practicing in arbitration. So I'll go quickly over why these national courts and bodies have this power. We know that it makes sense because they enforce their ontological obligation. That's the very purpose and the reason they're set out for. Same thing for national courts who have been established who can hear civil and criminal procedure to enforce liability obligations of counsel. That makes sense because they're here to protect the public, the profession, and national bars and courts have a duty to protect them. But in any event, the proper administration of justice requires that the ontological and liability obligation be decided by specialized bodies, such as those established under national law, which are independent from the adjudicator of the dispute. I'll give two very recent examples of arbitration-related issues that raise the ontological and liability obligations and therefore must be dealt with by national bars and courts. First, the claimant in an investment arbitration against Vietnam recently lodged legal malpractice claim in the US, alleging that his counsel colluded with a third-party funder to secure overpayment of their legal services. Obviously, this matter should be resolved through national disciplinary and civil procedures. Second, allegations have been made that the Geneva-seated arbitration was faked and used as a means to disguise illicit activities. Obviously, this matter should be resolved through national criminal procedures. But should the rules of national bars and courts concerning procedural ethical obligation apply to the conduct of counsel participating in arbitration proceedings? As I mentioned, no. This would create a double deontology problem. While it's true that national bars and courts have rarely enforced their procedural ethical obligation in international proceedings, there are, unfortunately, limited account of instances where they have. And more importantly, surveys report that most arbitration counsel are unsure whether they are subject to the procedural ethical obligations of multiple jurisdictions as part of their participation in arbitration proceedings. The result, therefore, is a system where we have counsel subject to different and sometimes conflicting obligations, even if these obligations are not always enforced. This can only harm the legitimacy and public perception of ethical regulation of counsel in international arbitration. Fortunately, we have instances of arbitration counsel who have managed to convince their national bar to disapply certain ethical provisions to the arbitral practice. This is the case of France, for instance, where the national rules on the preparation of witnesses now do not apply to arbitration proceedings. My submission is that this model should be followed by other national bars and courts, which should provide an arbitration exception related to the procedural ethical obligation of counsel. So I come to the end of my presentation. And I have one conclusion, one recommendation, and one point for discussion. Well, my conclusion is quite simple. Our report should take into account the points I've just highlighted. But based on these points, I also have one recommendation: that the inherent powers of tribunal to enforce procedural ethical issues be made expressed and be further clarified in arbitration rules. The LCIA guidelines are a good start. But other institutions should follow suit and provide more specific rules on the procedural ethical obligation of counsel. Here, the sixth version of the revised exit arbitration rules falls short. There's only a mention that the tribunal should treat the parties equally. What orders should the tribunal make? Those that are quote-unquote necessary. What about the evidence that the parties should produce? the evidence that the tribunal, again, considers necessary. Certainly, the discretion of tribunal to decide issues of procedure is a feat of arbitration that must be celebrated. But the reality today is that tribunals may feel unwary to enforce procedural ethical obligation in the absence of express textual basis enabling them to do so. One good example of this is party representation, the disqualification of counsel, sanction against counsel, etc. We know of the divide between the tribunals in the Slovenia and Romperol cases, but there are many other cases where this issue arose, including non-public one that I'm familiar with. The issue was recently in the headlines with the representation of the Venezuelan government in investment arbitration, and it has and will further be in the upcoming decade with the COVID crisis, be in the headlines in the context of bankruptcy-related issues in investment arbitration. Thus, a change of control of the domestic entity entitles the bankruptcy manager, what is effectively the respondent state, to change the counsel team. Now, my point for discussion for our committee is the following. Should arbitration rules explicitly include as a sanction that tribunal can report serious misconduct of counsel to the national bars and courts where counsel are licensed, who may lack the knowledge of the allegedly wrongful conduct? On its face, the contractually agreed confidentiality commitment of tribunal members appear to be clashing with such reporting. Yet, upon careful examination, national arbitration laws recognize confidentiality obligation, but subject to narrow exceptions. One such exception seemingly includes referring to national bars and courts the grave violation of mandatory professional rules. Perhaps tribunal members even have an obligation under their own national professional rules as licensed counsel to bring to the attention of national bars and courts such violation, although it's unclear how this obligation would apply to members of different national bars other than their own. With that, I've long exceeded my time, so I'll stop, but I look forward to our discussion.
Thank you very much, Jonathan, for this